I'd like to take a moment to try and answer a few of the questions that came up during the course of the discussion a moment ago. So I think what really Mr. Levy is asking for on behalf of the petitioners is for the rights and authority of an administrative judge to be more limited than the Maryland rules provide it to be. The Maryland rules give extensive, broad power on the part of to an administrative judge to make decisions about the assignment of cases. What we're hearing here is, no, that might be what the rules say. The case law may support that, but that's not what we want this court to embrace. In other words, let's just change the rules. Let's ignore all the rules and all the cases that clearly give broad discretion to that court.
How far does that go, though? I mean, if you make an assignment of a case, and there are decisions made in that case, preliminary decisions made in that case, the administrative judge can then come in and remove that case from that judge that's made the decisions and assign it to another judge? Is that what you're saying?
Your Honor, this case was never assigned to Judge Papura for purposes of making a ruling on a bifurcation motion. The bifurcation motions were pending before the case was assigned to her. Her assignment was a special assignment, and I know you asked that question. What does that mean in Baltimore County? Do the judges know what that means? So we know that when it comes to assignment, it's not all or nothing. You can assign a case in part. You can assign specific rulings to make on motions. You can assign a case for trial. A chambers judge may be assigned to rule on certain motions. There is no law that, as anybody can point to, with all due respect, that says the assignment is all or nothing. In fact, the rules say to the contrary. A case can be assigned for trial. It can be assigned for hearings. And we know as a practical matter, cases are frequently assigned for specific motions. Therefore, the question here is, what was actually given as an assignment to Judge Papura? Because we know from the Strickland case, I'm not going to go through the whole site, but we have it cited in our brief, we know from Strickland that a judge cannot make a ruling, doesn't have the authority to make a ruling in connection with a case or a matter that is not assigned to that judge. In Strickland, we had a judge who's had a case initially, the administrative judge, for a specific purpose, reassigned that case. What was the specific purpose? He didn't want that judge ruling on it because there was all types of factual questions that needed to be resolved. The judge was disputing whether he had signed off on a plea agreement that required him to revise that that defendant's sentence. And the administrative judge in that case said, you know what, we're going to reassign it. I'm reassigning for a specific purpose. I don't want you ruling on it. That was perfectly permitted by this court in Strickland. And in fact, the court went on to say, because what happened in Strickland is the judge who originally had the case signed, the one who it was taken away from, ruled after the assignment, after the case was reassigned. So at a point in time when that judge no longer had the case for that specific purpose of reconsideration of sentencing assigned to that judge ruled anyway. And this court ruled very clearly that that judge didn't have the authority to rule on that matter because the case had been assigned elsewhere.
If we don't have that level of sureness that you've just manifested, and we accept the notion that judges have the authority as judges to rule on bifurcation. I mean, there's no prohibition. Let's just assume that there's no prohibition. And I think that's true constitutionally. I could rule on it. If I'm assigned in Baltimore County, I gather that I could rule on a motion to bifurcate if I were assigned there, except that there would be this rule that I would observe. Is that correct? I mean, it doesn't take away my constitutional authority. That rule can't take away my constitutional authority to consider a case to which I've been assigned. Strickland is different.
Exactly. There's no constitutional limitation on what your authorities are with respect to matters that are assigned to you.
Okay.
So now the question is, what was the nature of the assignment? And I think I can clearly answer that for you.
Please do. I
will do that. Judge Papura came on board in January, I think, of 2012. The question was asked, what's the significance of what we submitted this morning? What we submitted was something that was distributed to all of the judges in Baltimore County Circuit Court to specifically clarify what would happen when cases were assigned, including special assignment. In fact, on October 31st of 2011, certainly this was well before Judge Papura ruled, there was a letter that was sent out on behalf of Judge Turnbull. It says, to all judges from Judge Turnbull, administrative procedures. There has been, and it's interesting, you say, well, what was the rule? There was confusion about it, even then. So there has been some confusion.
Well, but counsel, hold on. Administrative procedures, dash, or hyphen, Chambers judge. First sentence, there has been some confusion as to what the Chambers judge. That means...
No, with all due respect, this is not limited to the Chambers judge. We know that by virtue of the fact of the exhibit that's attached and that is being provided in accordance with the letter. So there's confusion going on about what the nature of what it means when somebody gets specially assigned and who has the authority to rule on what. That's clarified in this order. It specifically says, so now all the judges, the confusion is being resolved. They're getting an administrative procedures memo. It's provided to all of them in writing. There's an affidavit that it was specifically provided to Judge Papura. She could have made a mistake.
What was the reason for saying it was not limited to Chambers judges?
Yeah, I'm going to explain that in just one moment. If we look at the actual administrative procedures, we see that it addresses matters well beyond those within the purview of the Chambers judge. For example, it talks about bifurcate. Motion 2 should be ruled on by the administrative judge. Now, I would also direct your attention to, I don't know if you all have it in front of you or not, but the second page of it says scheduling orders, change of scheduling track assignment. Any changes to scheduling orders should be sent to civil assignment and will then be forwarded to the administrative judge, unless the case is specially assigned.
What does special assigned mean?
What special assignment clearly means, and everyone in that court knows, that you are assigned to preside over the trial of this case. You can rule on motions in connection with it, except to the extent you are prescribed from doing so, as clearly delineated in this order, which they all have and is all provided to them.
But there are many issues in that. We just talked about the constitutional authority of a judge. What you're saying is that this trumps the constitutional authority of the judge. Secondly, it says should be ruled on, not must be ruled on. And thirdly, it was ruled on. It was ruled on. It had already been acted on. We're not dealing with a situation where we're looking at it prospectively. We're looking at it after the judge has ruled on it.
It was ruled on at a point in time when that judge did not have the authority to rule, so that rule was invalid.
But also, you know, the issue of apparent authority, if we're talking about apparent authority that's been acted on, there's a whole body of law about that. You know, and voiding it. I mean, that's a completely different issue.
I would submit to you that if the circumstances, if Judge Papura and other members of the court didn't realize that bifurcation was being reserved by the administrative judge, and think about this. Special assignment occurs on
Let's just deal with the issue of should rather than shall then, or must, because we've certainly had cases on these issues.
Then,
how is it that all of a sudden a should becomes a must?
Then let's assume for a moment, for the sake of just hypothetically, that it really was assigned to Judge Papura. Let's assume she had that authority. We know under 2503, right, with respect to severance or bifurcation, that a judge can sua sponte rule on that matter. In this particular case, there was a motion for reconsideration that was pending in the Weinberg case, and frankly, in our Sullivan case, we were about to file a motion for reconsideration. but this change in circumstances occurred beforehand. So whether motion reconsideration or not existed, assuming for a moment that Judge Purpura had the authority, which I don't agree with, you understand, but I accept your hypothetical. So assuming she did, we know that there are revisory powers that the court has. They're not limited to that specific judge. We've talked about that before. And I think Mr. Levy even cited them a few moments ago, that a subsequent judge can rule on a matter that another judge ruled on before. And that subsequent ruling trumps the earlier ruling, even if that judge had authority. So I submit that she didn't have authority, but even if she did, that ruling was made at a point in time when, under everything else that we know that controls the ability of a subsequent judge to make a ruling on a similar matter or the same matter, that then becomes the valid ruling. It trumps the previous one. So either way, that's what we have.
He was acting in his judicial capacity.
Of course, and we know that, and I apologize, we know that as Mr. Brockman looked at, when you take a look at the judge's order, he specifically says, I read the motions, I read the rulings of Judge Purpura, and his order says, I find that it's not necessary. And in addition, I find that it's judicially uneconomical. So we can infer that because he read that, he didn't do it for sheer entertainment, when we certainly take into consideration the fact we expect judges to act impartially and appropriately, that we have that presumption that's available to us, one that's a heavy burden for them to undermine, that this judge made a ruling on the merits, took into consideration everything he should have, and he changed that ruling. So either way, I think we're good to go.
In October of 2011, was there a discrete judge or judges designated as a chambers judge in Baltimore County Circuit Court?
I think there's always a chambers judge.
So does that change daily? Does it change weekly?
I think it changes, weekly? But it might be, I think it changes.
I think it may be longer than that,
I apologize. I know it changes periodically. I'm afraid I don't know what it is.
So is that a singular person, or are there different chambers judges for different kinds of issues?
Well, for civil matters, I know there's one chambers judge that you would take a particular matter to. And I think the thing to be mindful of, and I apologize, but a special assignment is a rare entity. And what we have here, if we're basically saying that no judge can rule on bifurcation until a case has been specially assigned, we'd have no rulings to the day cases were about to take place, because that's when cases are typically specially assigned. Thank you.
Thank you, sir.